from Texas.
Mr. President, I'm glad I was on the floor to hear the distinguished senator from Illinois' comments about Section 702 of the Foreign Intelligence Surveillance Act. This is perhaps the most important law that most Americans have never heard of before. But here we are debating that, and the House having passed a bill and sent it over to us. It's our responsibility now to consider that bill. We all want to protect the privacy and constitutional rights of American citizens. That's non-negotiable. I agree with the senator on that point, and I think we all should agree. But the fact of the matter is the House bill is a reform bill. It's not Section 702 as it currently operates. This provides numerous guardrails, accountability measures, and other measures that I believe will limit, if not eliminate, the opportunity to abuse this authority to the detriment of American citizens. Rather, I believe this law must be passed in order to protect those same people. It's really important for the American people to understand that Section 702 is only available against foreigners overseas. Only foreigners overseas. If you want to get access to any information, even to a foreigner here in the United States, or an American citizen or a legal permanent resident, you've got to go to court and do what the senator says, and I certainly support that, which is to show probable cause that a crime has been committed. But we're not talking only about crimes, the crime of espionage. We're talking about foreign adversaries collecting information on American citizens that they can use to facilitate terrorist attacks, the importation of dangerous drugs, ransomware attacks through cyber crime, and the list goes on and on and on. But I think a fair reading of the House's bill provides the sorts of belt and suspenders approach that we need in order to reform the current practice because of the very abuses that our friend from Illinois mentions. Where I differ from him is the fact that we don't need to worry about acting on this bill by tomorrow night at midnight. Tomorrow night at midnight, the most valuable intelligence tool that's available to policymakers, including the President of the United States, will be eliminated. And what I'm talking about is additional collection of that information because, in fact, the very telecommunications companies that we depend on and that we compel to participate in the collection process will refuse to cooperate if they are not compelled to do so as a matter of federal law. We know that because some have in fact sued to protest that cooperation and that compelling of cooperation. So we need to think about not only what this program is now, but the blindness, the willful blindness we will incur in the future unless we act on a timely basis. And there's really no reason not to vote on the amendments, including the amendments from the senator from Illinois. And I certainly support the right of every senator to offer amendments to try to change the bill as they see fit. Every single day, information acquired through Section 702 protects our national security missions, and I want to mention a few of them. But just think about for a moment, when President Biden gets his intelligence brief each day, that's called the Presidential Daily Brief. It's a compilation of the most sensitive intelligence that's important for the President as the Commander-in-Chief to have access to. Approximately 60% of the information contained in the President's daily brief is derived from Section 702. So unquestionably, it is a critical resource to protect our country, not just for the commander-in-chief, but for other policymakers, including members of Congress, who happen to be on oversight committees, for example, which I am privileged to be. Well, one of the first things that comes to mind when we think about Section 702 of the Foreign Intelligence Surveillance Act, because it applies only to foreigners overseas who are a threat to national security and so identified. The first thing we think of is counterterrorism. And it's easy to see why, because this authority was first created in the wake of 9/11, the worst terrorist attack America has ever experienced. 3,000 of our fellow citizens killed that day. Section 702 was enacted in 2008 in response to threats posed by terrorist groups, and in years since, it has helped over and over and over again combat terrorism and prevent further terrorist attacks on American soil. Last year, for example, Section 702 helped the FBI disrupt a terrorist attack on critical infrastructure sites in the United States. In 2022, 702 data supported the planning of the U.S. military operation that resulted in the death of the leader of ISIS, the sequel to Al-Qaeda, a terrorist organization that has designs not only on its adversaries in the Middle East, but on Americans as well. In 2020, information acquired through Section 702 helped thwart a terrorist attack on a U.S. facility in the Middle East. And the list goes on and on and on. The point is that Section 702 is vital to America's counterterrorism missions, but its applications extend far more broadly than just on counterterrorism. It's also a critical tool in the fight against fentanyl, which took the lives of 71,000 Americans last year alone. I've been to 6 high schools in Texas where parents, grieving parents, say their child took a pill that they thought was relatively innocuous, Percocet, a Xanax. I know we wish our kids never would take things like that, but they certainly didn't think they were taking a pill that would kill them, but that's exactly what happened, because it was a counterfeit pill that looked like a regular pharmaceutical drug, but it was laced with fentanyl, and it took their life. 702 is a critical tool in combating fentanyl, which is a leading cause of death for Americans between the age of 18 and 45. That's an incredible statistic. In one example, the intelligence community obtained information under 702 that a foreign actor supplied a pill press machinery to a Mexican drug cartel to make fentanyl, which is what happens. The precursors come from China. They make their way into Mexico. They're combined and then processed through an industrial capacity pill press to make it look like a normal pharmaceutical, and then smuggled into the United States. That machinery, that pill press, was capable of producing millions of fentanyl pills, not per year, not per month, not per day, but per hour. We know that one pill can kill. So this machine alone could produce millions of lethal doses in 1 hour. The good news is that this information was uncovered thanks to 702 and was acted upon. And the pill press and other equipment that were seized before they could end up in a cartel's drug lab. But this type of success story is not isolated. Last year, 70% of the CIA's illicit synthetic drug disruptions stemmed from information gathered through Section 702. I know we think of the CIA as our intelligence agency, and it is one of our principal intelligence agencies, but one of their missions is a counter-drug mission. And they were able to use Section 702 to disrupt 70%, or it comprised 70% of their synthetic drug disruptions just last year alone. This intelligence gathering capability is vital to our efforts to stop fentanyl and save American lives. And there's no question that the fight against the fentanyl would take a major step backwards if 702 went dark. Now, I want to that currently collected information could be queried. They could have a search selector to look among information that's already been lawfully collected. But there would be no way that the telecommunications companies from whom this information is collected would cooperate absent a federal law compelling them to do so. As I said, some have sued and claimed that they should not be required to cooperate. Of course, intelligence professionals uncover information about far more than just terrorism and drug trafficking. Section 702 also helps the United States government stop the proliferation of weapons of mass destruction. 70% of the intelligence community's successful disruptions of weapons of mass destruction in the past few years have stemmed from 702. This intelligence also helps disrupt our adversaries' efforts to recruit spies or people they try to recruit here in the United States. 702 helps identify and respond to cyber threats. In 2021, you may remember the Colonial Pipeline ransomware attack, where cyber criminals froze the computer systems of the Colonial Pipeline and shut it down, which supplied the major supplier of gasoline and diesel for the East Coast. And they said, we're not going to unlock that network until you pay the ransom. Well, it was Section 702 because the masterminds of this effort were overseas, primarily in Russia, that we were able to use 702 in order to identify those foreign actors in a way that allowed then the FBI to connect the dots and to dismantle that criminal network. Every day, America's intelligence professionals rely on Section 702 to gather timely and actionable intelligence to keep our country safe. Well, there's no question, and I haven't heard any one of our members here in the Senate say that 702 is not helpful, it's not necessary. But they're concerned about privacy, and I am too. That's the balance we must strike between security and privacy. We need both. Well, the Fourth Amendment to the United States Constitution protects Americans from unlawful searches and seizures. Now, that applies in every instance where there's an investigation, whether it's by the FBI or by the local police department. Law enforcement cannot search your home or monitor your communications without going to a court and showing probable cause that a crime has been committed. But there's a lot of confusion about where that might apply in this context, because what we're talking about is not crime in the sense that our criminal laws ordinarily apply in America. What we're talking about is foreign espionage and hostile activities directed toward the United States that have not yet occurred. Ordinarily in America, we don't do anything to try to prevent crimes from happening. We punish crimes once they've occurred, after we've investigated them and prosecuted them. But we don't want another 9/11 to occur. We don't want innocent Americans to be killed in a terrorist attack. And it's not okay to say, well, we'll wait until the terrorists commit that act, and then we'll try to find them and punish them. We want to stop it. And that's where 702 is so important. And it is not true that 702 gives the authority to the intelligence community to target Americans. That's illegal. The senator from Illinois mentioned a number of times where there was inappropriate and frankly illegal use of this information. And those individuals in some instances have been disciplined, some instances have been prosecuted, and that's appropriate. But what the hell, for example, FBI rules and regulations around the use of 702 and codifies them. In other words, it's not discretionary, it's not a matter of agency rules, it's a matter of federal law. And Speaker Johnson, I know, sent out a long list, and perhaps we ought to consider that more closely, a long list of reforms that this bill includes that would make that sort of activity far less likely. Now, I say far less likely because I doubt you could pass any law or any rule that would prevent somebody from abusing them. But we sure ought to make sure that we minimize the possibility, and we ought to make sure that people who do so are held accountable. And that's what this FISA reform bill that the House passed does. Again, this bill allows the intelligence community and the Department of Justice to obtain information on foreigners located outside the United States. So here's one of the questions or one of the issues posed by our friends who have a different view on this. And that is because when a foreigner talks to a U.S. person, well, that should send off flashing red signs, or at least yellow lights. But federal courts, at least 3 federal courts, including the Foreign Intelligence Surveillance Court and 2 other federal circuit courts, have held that there is no violation of the Fourth Amendment of unlawful searches and seizures of Americans if that is incidental collection, incidental to the authorized collection of foreign communications of people overseas. And how is it that we could possibly expect anybody to get a warrant when we don't even know who these individuals are talking to until after the fact? What happens then is very important and is very different. And that is if the FBI or any law enforcement agency wants to go a step further and ask for more information about the American citizen or U.S. person, then existing law requires that they get a warrant. Requires them to go to court, Foreign Intelligence Surveillance Court, Article III judges appointed by the Chief Justice of the United States Supreme Court, and to get a warrant based on probable cause that this individual is aiding and abetting a foreign adversary or has committed a crime, like espionage. But the Fourth Amendment to the Constitution does not apply to foreigners who live abroad. Where this issue raises heightened concerns is the incidental collection, which I mentioned a moment ago. That is, if a foreign target who lives abroad is communicating with an American on U.S. soil or a U.S. person, like a legal permanent resident, intelligence professionals will receive both sides of that conversation. Again, what I've said, multiple courts have examined the constitutionality of this incidental collection, and in each and every case has determined that 702 complies with the Fourth Amendment. For example, the Second Circuit Court of Appeals in 2019 considered that very question. The court determined that, quote, the government may lawfully collect the emails of foreign individuals located abroad who reasonably appear to be a potential threat to the United States. The court added that once it is lawfully collecting those emails, it does not need to seek a warrant to continue to collect emails between that person or other persons once it learns that some of those individuals are United States citizens or lawful permanent residents or are located in the United States. But as I said, once this incidental collection has occurred, if the law enforcement agencies like the FBI want to go further, they have to get a warrant before they can collect other information about that American citizen or U.S. person. That's no longer incidental to the foreign intelligence gathering of somebody overseas. That's a direct investigation of that person, and it requires a warrant and probable cause. Well, what I'm talking about in terms of incidental collection is not a novel concept. For example, when a law enforcement officer executes a search warrant as part of a money laundering investigation, if the officer enters a home and sees illegal drugs, for example, in plain view, officers can seize that evidence even though it's unrelated to the warrant. That same sort of principle applies here. The Second Circuit, the Ninth Circuit, and the Tenth Circuit Courts of Appeals have all looked into this matter, and the Eastern District of New York has as well. Again, every court that's considered the lawfulness of the 702 program found that it complies with the Fourth Amendment. So there's no argument, really, even among people who have different points of view. There's no argument that 702 is vital to our national security. The FBI and the intelligence community rely on that authority to combat terrorism, to disrupt drug trafficking, prevent cyber attacks, and much, much more. I believe that what's really being argued about here, which we ought to go ahead and lay on the table, is a lack of trust in how these rules are actually applied and practiced. And part of that justifiable concern is based upon abuses in the past. And those ought to be investigated and prosecuted, and those people who violate the law ought to be held accountable. But what the House has done is proposed a reform bill which reduces, if not eliminates, the chance of taking those same sorts of actions, and certainly has provided for accountability, including prison sentences for people who do violate those rules. So this proposal goes about as far as you could go without destroying Section 702 to make sure that the privacy rights and the constitutional rights of American citizens are protected, while at the same time making sure that we can maintain this flow of valuable foreign intelligence to help protect the American people. This legislation codifies reforms that were implemented by the FBI a couple of years ago, which have reduced noncompliance to about 2% of their queries. And these reforms have already proven to work. As I said, the Department of Justice conducted a review last year and found that 98% of the FBI's queries were now fully compliant with these new and enhanced and improved requirements. And those would be codified into law under this bill. So I appreciate the sensitivity that all of us feel about the constitutional rights of American citizens. None of us want to allow any violation of those rights. We're sworn to uphold and defend the Constitution and laws of the United States. And I'm confident that each of us want to be loyal to that oath. But at the same time, we have a responsibility to protect the American people from the sorts of threats that I've described. And allowing 702 to expire tomorrow night would simply blind not only the President of the United States, but us as policyholders, people responsible for protecting our great nation, would blind us to the threats that future collection under 702 could provide. Because there is no way that these telecommunication companies are going to cooperate absent a federal law compelling them to do so. So who would be the winner in all this? Well, let's call out a few winners in this if 702 goes dark. China, Russia, and Iran. And you might throw in North Korea. It would limit our ability to understand the threats we are facing here in the homeland before it's too late. So there's a reason why, Mr. President, the intelligence community calls Section 702 the crown jewels of their ability to protect and defend the United States and the American people. And it's absolutely imperative that Congress reauthorize Section 702 with these reforms before it lapses tomorrow night. And I'm optimistic that working together, we can get the job done. Mr. President, I yield the floor, and I'd note the absence of a quorum. Oh, I beg your pardon. I'll withhold the request.
Mr. President.
Senator from Illinois.
Mr. President, I want to thank my colleague from Texas. Though we may disagree on some aspects of this important law, once again, he's made a professional and thorough presentation of his point of view. I hope that those who are following this debate understand it, because it is complicated. Complicated to understand, complicated even to explain. But it seems to me there are a couple areas here that I'd like to express a point of view on the senator from Texas's comments. Number one, I am in favor of keeping Section 702, no question about it. When it comes to its initial purpose, we still need it to keep America safe, and we need it in many different aspects. You mentioned the fentanyl situation. It's horrible. The most recent figures I've received from the Drug Enforcement Administration suggest that over 100,000 victims a year now of fentanyl in the United States. It's the deadliest narcotic. There are at least 2 cartels in Mexico that are generating this fentanyl, Jalisco and trying to recall the other one. But they are actively engaged, and Drug Enforcement Agency is monitoring what they're doing. Do we want to use our capacity to get into that business model and to try to find out more information to thwart deliveries in the United States and more fentanyl in the United States? Of course, sign me up. The question comes down to a practical question. Let's assume for a moment that we decide that we want to know if someone involved in one of these cartels is making a drop in the United States. We can use 702 because we are dealing with foreigners in a foreign land. That's the premise of 702. So if we would intercept communications of someone in that cartel in Mexico, the question is, what do we do if the information that they disclose in this conversation includes reference to an American? And what right do we have to go any further in questioning that American's involvement with the cartel? That's when we run into the Fourth Amendment, as far as I'm concerned. And it's a serious question as to whether or not we can ask any questions about text, emails, or phone conversations of the American whose name came up in the conversation that we intercepted of a member of the cartel. That's where we have probably a difference of opinion. How far can we go? I believe if we're going into an inquiry as to what that American's involvement is with that cartel, the Fourth Amendment applies. At that point, we need a warrant. Does the Senator, through the chair, I asked if the Senator would like to comment on what I've said so far.
Mr. President, I appreciate the opportunity to engage my friend and colleague, the distinguished chairman of the Senate Judiciary Committee and a distinguished lawyer in his own right. So this is his wheelhouse. But I appreciate the question because I think it actually, maybe there's a nuance here that either I misstated my position because I'm of the same mind you are when it comes to an American citizen who's mentioned in a communication with the foreign actor, because this is designed to deal only with foreign actors. What I was referring to as incidental communication is where there's communication between the foreign actor and a U.S. person, and we call it that a U.S. person because it can also be a legal permanent resident, but for basically what we're talking about is U.S. citizens. So when that's incidental collection, when there's that contact between a target, foreign target, and the American citizen, that's considered to be incidental collection, and no court has said it violates the Fourth Amendment. But I agree with the senator that if, in fact, there's a mention of an American citizen in that communication and the law enforcement agencies want more information about that American citizen, they have to get a warrant. They have to go to court and establish probable cause in order to get that information, because that's what the Fourth Amendment's designed to protect. I hope I've understood senator's position.
Well, and I hope I understand your position as well, because I think we just reached a point of agreement. And the question is, where do we go from here? If the foreigner names an American citizen, that's incidental. If our agency of government decides that they want to explore conversations, phone conversations, texts, and emails of that named American citizen, I think we both agree at that point you've reached Article 4, or the Fourth Amendment protection that requires a warrant. All I've tried to do with my amendment is to condition that situation that I've just described to you to be protected in the law, with 3 exceptions. I create 3 exceptions. An emergency situation. I mean, you can imagine, and I can too, after living through 9/11 and other instances, sometimes you have to move and move quickly, and even the Fourth Amendment warrant may be questionable. And the second part is cybersecurity, where that may be part of it. And the third is where that American citizens happens to be asking to be protected for fear that something's happening to them that they don't want it to happen, so that they ask the agency of the government to go forward and to inquire as to that foreigner because they want for their own protection the agency to do it. Those 3 things are built in my amendment as well. So we may be perilously close to an agreement. I don't know. I won't presume that. But I think what we've said so far is something that I can live with.
Mr. President, if the senator from Illinois would permit me to respond, I think there's the two challenges I think we face. One is that I think the exceptions that you mentioned basically will mean that the status quo remains, because almost each of those 3 exceptions would be allowed under current law, and so then the amendment would not really change any much in the way of practice. I may be missing something, but you mentioned cybersecurity, emergency situations, and the third is?
Consent of the person, the American.
And, but here's the practical problem. The House of Representatives has passed this bill, and one particular important aspect of this is a warrant vote that was on a tie vote. And so this bill, this law lapses tomorrow night at midnight. And it's obvious to me that we're not going to be able to change this bill in a way that then could go over to the House and get picked up and passed before midnight tomorrow night. So basically what we're forced with is a lapse in these authorities during the interim. And I'm not even confident that the House could even pass another bill, even with these amendments. So I don't question the goodwill and the intentions of the senator from Illinois. I think he wants to do what I want to do, which is to protect our country and to protect the rights of American citizens. But I think as a technical matter, that the exceptions he has will swallow the rule of that his amendment would establish, but perhaps even more basically, by just through passage of time, it would prohibit us getting this bill to the president's desk in time to keep these authorities in effect. There's no question that our world is more dangerous now than at any other time in the recent past, I would say since World War II. And so I don't think we could risk going dark by having this authority lapse on future collection, either for the benefit of the Commander-in-Chief, the President of the United States, or the rest of us. I want to thank the Senator for giving me a chance to answer a few questions and present my point of view.
Mr. President, I'd like to thank my colleague from Texas and say to those who have witnessed this came dangerously close to an actual debate on the Senate floor, bipartisan debate. That happens so seldom that those who have witnessed it should probably call their friends. And seriously, I respect the senator from Texas, and though we may disagree on some aspects of this, I respect his presentation and thank him for answering the questions. I yield the floor. Suggest the absence of a quorum.
hoa chứa chan tình thương. Ngày mai xa cách hai đứa hai nơi, phút gần gũi nhau mất rồi, tạ từ là hết người ơi. Tiếng ve nức nở buồn hơn tiếng lòng, biết ai còn nhớ đến ân tình không. Đường xưa in bóng hai đứa nay đâu, những chiều hẹn nhau lúc đầu giờ như nước trôi qua cầu. Giá biết bạn lòng ơi, thôi nay xa cách rồi, kỷ niệm xin nhớ mãi. Buồn riêng một mình ai, chờ mong từng đêm gối chiếc, mối u hoài này anh có hay. Nếu ai đã từng nhặt hoa thấy buồn, cảm thông được nỗi vắng xa người thương. Màu hoa phượng thắm như máu con tim, mỗi lần hè sang kỷ niệm, người xưa biết đâu mà tìm. Giá biết bạn lòng ơi, thôi nay xa cách rồi, kỷ niệm xin nhớ mãi. Buồn riêng một mình ai, chờ mong từng đêm gối chiếc, mối u hoài này anh có hay. Nếu ai đã từng nhặt hoa thấy buồn, cảm thông được nỗi vắng xa người thương. Màu hoa phượng thắm như máu con tim, mỗi lần hè sang kỷ niệm, người xưa biết đâu mà tìm. Màu hoa phượng thắm như máu con tim, mỗi lần hè sang kỷ niệm, người xưa biết đâu mà tìm. Màu hoa phượng thắm như máu con tim, mỗi lần hè sang kỷ niệm, người xưa biết